Okay, imagine this. You're on your feet in the federal court. The judge is looking right at you. The pressure, it's intense. But you know what separates the really great barristers from the just good ones? It's not always about some brilliant last-minute argument. It's about mastering the rules of the game. Knowing procedure isn't just about ticking boxes. It's about having a toolkit of, well, strategic weapons. So let's dive in and really master one of the most critical parts of that toolkit, Division 26 of the Federal Court Rules.
All right, so today we are unpacking 5 absolutely essential tools that every single litigator needs to have ready. First, we're going to talk about how to deliver that knockout punch to a hopeless case. Then, the tactical retreat, how to withdraw a plea when you need to. After that, we'll get into how to end a proceeding altogether, the huge question of who pays the price for stopping, and finally, what happens if you want to start the whole fight all over again.
All right, let's kick off with our first scenario. Your opponent has just filed a case against your client. You're reading through the pleadings and you just get this feeling. You realize it's completely, utterly without merit. It's a total waste of time, it's a waste of your client's money, and you need a way to shut it down, right now, before it gets any legs.
So what's your weapon of choice? It's Rule 26.01, Summary Judgment. You need to think of this as your procedural knockout punch. It's designed to dispose of a case early when it is crystal clear that one side just cannot win. For your bar exams, you have to remember this. Rule 2601 is your go-to for meritless claims.
Now, listen up, because this is a critical change you have to know. The old test was no reasonable cause of action, and let me tell you, that was an incredibly high bar to clear. The new test, which comes from Section 31A of the Federal Court Act and is right there in Rule 26.01, is no reasonable prospect of success. And the cases are really clear on this. This is a less stringent test. It gives the court a lot more flexibility to stop a case that's doomed from the start.
So what does no reasonable prospect of success actually mean in practice? Well, the courts have given us the answer, and this is the phrase you need to burn into your memory. The question is whether the prospects of success are real as distinct from fanciful. It's that simple. If the other side's chances are just fanciful, you have your grounds for summary judgment under, say it with me, Rule 26.01.
Okay, tool number 2 in our kit. Let's switch gears. Say you've already filed a defense in a proceeding, but as the case develops, you realize one of your arguments, well, it isn't as strong as you first thought. Or even worse, you've accidentally admitted something you really shouldn't have. You need to make a tactical retreat.
The rule you're reaching for here is Rule 2611. This is your specific instrument for withdrawing a plea that you've already put on the record in a defense or some other pleading. And look, it's not just about correcting simple mistakes, it's a strategic move to refine and strengthen your case as it moves forward.
Now, Rule 26.11 gives you 2 very different paths, and I'm telling you, this is a classic exam trap. So under Subrule 1, if it's just a general plea, it's easy. You just file a notice of withdrawal. Done. But, and here's the danger zone, under Subrule 2, if what you're trying to withdraw is an admission, you absolutely cannot do it on your own. You must have either the other party's consent or the court's leave. You have to get this right because getting it wrong can cause you serious, serious problems.
All right, let's move on. Sometimes it's not just a single plea you need to change. The entire landscape of the case has shifted. Your client calls you up and says that for whatever reason, commercial, personal, strategic, they just don't want to continue with the litigation at all. It's time to pull the pin.
The formal procedure for doing this is all laid out in Rule 26.12, Discontinuance. This is the rule that lets a party who started the whole thing, the applicant, formally end their own proceeding, either the whole thing or just a part of it.
Okay, let's make this crystal clear, because this is a point of constant confusion. Discontinuance, under Rule 26.12, is an act of the party. You, the lawyer, file a notice. Dismissal, on the other hand, is an act of the court. The court makes an order. You know, the source material points out that it's quite wrong for legal practitioners to ask the court, by consent, to order that the proceeding be discontinued. No. You either ask for dismissal or you ask for leave to discontinue. You have to know the difference.
So how do you actually do it? Well, Rule 26.12, Subrule 2, gives you 3 distinct paths. Path number 1, you can do it without anyone's permission if it's super early in the case, like before the first court date or before the pleadings have even closed. Path number 2, you can do it with the other side's consent anytime you want before judgment. And path number 3, you can always just ask the court for leave to discontinue. 3 options, all there in Rule 26.12.2.
So, you've filed your notice of discontinuance. The proceeding is officially over.
Phew. But a crucial question immediately follows. Who pays for all this? Your client is definitely going to ask, and the court is going to demand an answer.
The starting point, the default rule, is simple and pretty unforgiving. You have to remember this number, Rule 26.12, Subrule 7. It basically says that unless you've made some other agreement or the court orders something different, the party who discontinues is on the hook to pay the other party's costs for whatever part of the claim was dropped. The rule of thumb is simple. You stop the fight, you pay the price.
But it's not 100% automatic. The court always keeps discretion over costs. This is especially true when you're discontinuing with the court's leave under that third path, Rule 26.122C. The judge will look at how both parties have behaved and the real reasons for stopping the case. So, while that default under Subrule 7 says the discontinuing party pays, the court absolutely can and sometimes will order something completely different.
Okay, we're on to our final section. Let's talk about the aftermath. You've successfully discontinued a proceeding. What happens now? Can the other side just turn around and sue you again for the same thing? And what if your client wants to have another crack at it later? This is a really critical point, and it's covered by Rule 2614. Just because you discontinued a proceeding, that doesn't mean the issue is finally resolved. It can't be used as a defense if the other party decides to start a whole new case about the exact same issue. Think of it as hitting the pause button, not a final verdict.
And this sets up a very common, very practical problem. So your client discontinues a case. They become liable for the other side's costs under Rule 26.127, but they don't pay. Then, a few months later, they decide they want to launch a new case on the very same grounds. What do you think happens then?
And here we have it, the final piece of our Division 26 puzzle, Rule 26.15. This rule gives the other party a really powerful remedy. They can apply to the court to have your client's new proceeding stayed, which means completely halted, put on ice, until your client pays the outstanding costs from that first case they discontinued. It's a powerful check to make sure you can't just walk away from your financial obligations and start all over again.
So, as we wrap all this up, I want you to think about this. Rule 26.01, 26.11, 26.12, 26.14, and 26.15, are they just dry procedural steps you have to memorize? No way. They are powerful strategic assets in your toolkit. Knowing exactly when to deploy summary judgment, how to perfectly execute a tactical withdrawal, or understanding the full costs and consequences of discontinuance, that's what elevates you from someone who just knows the law to a barrister who really knows how to win.